So today we are going to discuss on intellectual property rights and introduction, and this is the first lecture. And in the first lectures our learning outcomes will be these are the followings: creativity, discovery, inventions and innovations, concept of valley of death in innovations, concept of property, concept of intellectual property, concept of intellectual property right, and classifications of it. So let's get started. Firstly, we'll be discussing on this creativity. What is a creativity? In our society, everyone of us we find that the creativity, regarding this creativity, there is an enigma. And what is that enigma? Enigma says that some people are creative and some matters, some issues are creative. But trust me, over the years we have been working, and the many scientists have been working on these creativity aspects and the innovations aspects, and based on that, few things have been already uncovered. That's a few principles have been developed. That is a creative diversity principles. First one is all people are creative. Second principles is the creativity is diverse. Not that only in particular field a creativity will be limited. And creative diversity principle third, it says it's a contextual. Some says that it's a contextual, but in almost in every cases there is a creativity aspects can be embedded. And creativity diversity principles, the last one, there is a no ideal kind of creativity. That means in any field there can be creativity. So what is the creativity and what is the motivations behind this creativity? Primarily, there are two motivations behind it. One is a subjective motivation, another one is a objective motivation. Subjective motivations, it clearly says, as we are a human, we are human species, and we are the part of this physico-psycho impact. And based on that, what we think that we if we feel that we are a creative persons, that means there must have some uh, emotional or internal motivation comes within for that particular creativity. That means there are creativity, the motivation also is within us. If it comes from within us for whatsoever the reasons, that is called the subjective. And another one is the objective, when motivation is external, not the internal, like the previous one I said. So that's a outward motivation. Say for a commercial interest in any field, that is actually is a commercial motivation, is an external motivation. So that's a objective motivations. So you can say there are two perspectives. One is a subjective perspective, another one is a objective perspectives of creativity. Let us try to understand, because these concepts are very important to understand our intellectual property rights, because intellectual property rights protects our creativity. So let us try to understand what is the basic difference between the discovery and the inventions. Discovery is a kind of thing it is already existing on earth. What we have done, we have simply unearthed it, nothing else. It was existing, there was no human intervention. But in case of inventions, there is a human interventions. The name clearly suggests inventions mean some human interventions is connected, and this is why it's called inventions. Let us take few examples on that. Lightning in a rainy days, you will find that that's a Sir Benjamin Franklin once discovered this one. We call it a discovery. But cave people, when they tried fire, when they're crushing stones against another stones, that is primarily and basically a fire making procedure. What is the basic difference then discovery and inventions? Discovery cannot be happen with our will. Inventions happens with our will, because can you do a discovery on your own? No. Discovery happens accidentally, but inventions we can do it. We can light a candle on our will. So this is the basic difference, and one of the most important is a reproducibility. As we can do it as a human species, we can do any inventions on our will based on our uh, motivations. we can create it, we can do it. So there is an internal motivation or external motivation, but inventions normally created based on our human interventions. So reproducibility is one of the most important or distinguishing factor from discovery. So what is the innovations? Another new term. The picture clearly says that we understand the impact and the uses of umbrella. We understand it. But if you follow the diagram, if you follow the picture, we'll find that someone is using umbrella in some other different way, which is not common. He had actually toppled down that umbrella and he is using for its for rain as well as saving water. Saving water was not the primary cause of using umbrella. That's a new use, and it's an ingenuine use of the candidate who are actually using in that way. So that is a inventions related with the innovations. What is innovations? Umbrella was invented by somebody else, but the value additions, that means saving water in addition to the to protect from the rainwater, that is a new use. That new use somebody has created. So value added, when a value is added with the already existing inventions, is called the innovations. So we'll primarily focus on the creativity has many perspectives, but primarily our discussions will be limited on the applied aspects. In applied aspects, we have already uh, had a very brief tour. That's we try to understand discovery, inventions, and the innovations. So if you focus on why this IP, intellectual property, why should you study it? If you follow this picture, you will find that from waking up at the morning to going to the bed, you will find the kind of commodities, the kind of material object we use, including all digital tools and the non-digital analog tools, everything somebody has invented sometimes. And everything is protected, be it a watch, be it an alarm clock, be it a machines, be it a toothbrush, maybe it's a Coca-Cola, McDonald's, made any digital tools, jewelry products, shoes, cars, everything is covered under these intellectual property rights. So it plays a very pivotal role in our human civilizations. So let us try to understand the procedure, how this procedure, diffusion, invention. Inventions is a kind of thing. Suppose you have invented something, and any invention starts with a new idea. But idea, trust me, idea is not protectable. Idea needs to be manifested, idea needs to be expressed, only then it is protectable. So creations of new idea, that means putting your idea into action. Then conceptualizations of new idea, that means when you have taken a decision to innovate. Then commercializations of new idea, that means when you are trying to go for new idea for commercializations. But it is not so easy to commercialize or marketize your product, your invented or innovated products. So you have to cross the limit. You have to cross a barrier. What are the barriers? Says for a drug molecule. In a laboratory 10 molecules have been discovered. Out of these 10 molecules, only 2 molecules or 1 molecule, most of the cases 1 molecule, comes to the market and see the daylight. So what is behind it? What is behind it? That means a customer's preference, say for a particular tablets or capsules aroma, whether that customer prefers it or not, and the price, whether it's a cost effective to the common man or not. From various parameters, it is judged by the market, and it is called value update. So one inventions can become only innovation when market accepts it. That means customer accepts it, and only then when market accepts, when customers accept, only then it gets an opportunity to diffuse in the society. So this is the uh, way a new idea expressed, commercialized, and diffused in the society. And this is way a very interesting book is also there on the Rogers book. It's basically a concept of Rogers concept, diffusions of innovations into the society. So let me delve a little bit more through some pictorial depictions. You will find that journey through a valley of death. Any inventions, it has to go through a valley of death. This valley of death is basically a misnomer. And valley of death says You have to cross the barriers and the difficulties, and only then you can reach to the market, potential market. Every year, World Intellectual Property Organization, a sister organization of the United Nations, possibly some of you know, is a headquarter in Geneva, Switzerland. In collaborating with Cornell University Department of Management, Business Management, they publish every year Global Innovations Index, GII. The last year, latest Global Innovations Index, India's position has escalated from 81st in 2015 to 39 out of 130 countries, and it is not so easy job. Every country, whether a country is innovative, whether a country is creative, that is judged by these global innovations index. When a country is escalating its positions, that means a country is becoming much more creative than the previous days. As we discuss a little bit on the innovations, inventions, and the discovery, from that point of view, you understand it, how it is important, how it is important to a country become creative or innovative in the today's world. In the today's world, no country can live in isolated manner or in an islandic manner. This is not possible. We have to collaborate with other countries. We have to have some mutual interest, research interest. We must have some commercial interest with other countries. Otherwise, we cannot survive in this a very complicated commercial arena. So, in this world, including the universities, societies, and include the personal growth, everywhere creativity and innovation plays a very important role, including any countries like India's growth is also very much connected with our innovations. So, as I talked to you a little bit before, that you might have a very good idea. Idea is a king. We all understand it, but idea means nothing. Without execution, idea means nothing. So, if you have an idea, it needs to be expressed. If you think that your idea is having a very commercially potential idea, so it needs to be expressed. If you want to protect it, you need to think about the intellectual property rights. Every inventors, every creators, rather a neutralized term is a creator. If you think you are a creator, you are creating something, that means you have some very good idea that might have a commercial interest. If you want to protect it, you must think about this intellectual property rights, and it's the various components, and that this is the tool by which you can protect your creativity. IPR has different classifications. Yeah, different categories are there, different components are there. We'll be discussing in the next few slides. But let us try to understand. We understand the creativity. We understand the various creative factors that prompt us to create something. We understand it. But what is important is, why should we protect our creativity? If you think that your protective creativity is a potential commercial interest, you need to protect it, because I'll be discussing that your intellectual property is your property. It's like suppose you are having a flat, suppose you are having a car. For whatever the reason, if you want to sell it, you can sell it. For whatever the reason you want to rent it. So you can reap any benefit out of it, any economic benefit out of it. So intellectual property rights also says very similar thing, very similar story to it. Because if you think your creative idea is having a very good commercial interest, so what you need to do, you must think about how to protect it. So we'll be discussing about these protectivity aspects and the various uh, critical aspects that helps you to understand the basics and the fundamentals of intellectual property rights. So before jumping in to understand the intellectual property right, we must understand what is property. Property, like any property, like your flat, car, as I said, or anything, land, anything, any property that you can touch is a property. And property has a different connotation, different understanding, and different perspectives. Primarily, there are three understandings for your property. First one is a scientific understanding. Scientific understanding for our today's discourse is not so important. Why is it not so important? Because it deals with the physical properties and the chemical properties of a material or element that is no way connected with the today's discourse. Let us focus on our rest of the two understanding. One is a legal understanding, third one is a economic understanding. So what legal understanding is saying us? Legal understanding is saying us is a questions of alienations. Alienations mean it's a right. When you are saying that this is my flat, when you are saying that this is my car, that means you are clearly saying that don't use my car, don't enter my flat without my permission. It's called the rights of alienations. Aliens means external things. So no external persons can have any permission to use my material over which I have some ownerships. There is no permission. So that's a legal understanding. That means as the exclusivity. Legal understanding says a right of alienations. And the third one is a economic understanding. Suppose you want to sell your property that we normally call, as our normal people call it, a property, like your flat, land, and anything. You can sell it, and the economic benefit will go to, after selling, economic benefit, it goes to you because you are the owner, legal owner. That means economic benefit will directly go to you or a joint owners of that. So for understanding of our property, intellectual property and intellectual property right, these two understandings are very important. And property has two different other understanding. Let us discuss that. First one is a tangible property and intangible property. Before that, just think, imagine, can you touch your dream? Can you touch your idea? No, it's not possible. So that comes within you. That is not touchable. That is, you can feel it. You can feel it. But you can touch your table. You can touch your wall. You can touch any physical object you find. So that's a tangible property. Intellectual property, it comes from human mind, human brain, and that is called intangible property. That cannot be touched. That can only be felt by someone. That can only be thought by someone, dreamed by someone. This is why I told you, nobody can touch dream. Nobody, except you. That means you have dreamed. That means you can share your dream. You cannot share. So that is a kind of thing, intellectual property. If you have a very good applied idea that can solve a problem, that can potential have a commercial interest and a technical solution to a technical problem, it's called a intangible property. And intellectual property is an intangible property. But interesting aspects of that, as I said, that idea is not protectable. Yes, idea is not protectable. But if you think that your idea is having commercial interest, if you think your idea is a potential to solve a societal problem, technical problem, scientific problem, certainly it needs to be expressed if you want to protect it. If you want protection of your idea, it needs to be expressed in some form so that world can see. World wants to protect your idea, but world needs to see it before that, and that is a tangible property. So the moot point of my discussions is, if you have a very good idea, as I said, it needs to be expressed. That means your intangible idea, which is not touchable, that idea needs to be expressed. That means a intangible property needs to become tangible property, and only then it becomes protectable. So why I fear? I already said, to protect your creativity and innovation, get an economic return, and for any kind of inventions, you have to burn midnight oil. You have to toil it. You have to toil hard. You have to work hard. Otherwise, you cannot develop a solution, be it a scientific solution to a scientific problem or a technical solution to a technical problem. It's not so easy. So that's a very difficult thing, that you have hard worked and come up with some solution that is also very important to solve a societal issue, technical issues, scientific. So as you own, as I told you, as you own your idea, so the expressive form, the way it has been manifested, you are the owner. You are the owner. You own it. You sell it. You rent it. You can give some donation to your property. The way we sometimes we donate our property to somebody else, to our friends, charity organizations. Very similarly, you can also donate your intellectual property to university, society, the persons, anyway. And the most important, exclusivity factor. The way we stop others to enter our house, trespassers will be prosecuted kind of notice normally we post in our at the entry point of our home. Very similarly, if anybody wants to use your intellectual property, that would be legally dragged and the legally punishable offense. So these are the rights, very similar rights. There is no such difference, because if you are having a flats, cars, or any physical property, the kind of rights you enjoy for your property very similar. Properties are there: rights to own, right to exclusive use, right to disallow others from its use, right to sell, right to transfer, right to donate, right to rent, right to lend, and right to derive profit out of it. And always remember that property involves a bundle of rights. Always a bundle of rights. Many rights comes together. And then what happens when one right is violated by one person's? We'll gradually come to know over it. So let us try to find out the basics of our understanding. What is intellectual property? We understood a little bit. We had a very brief tour on property. In understanding property, we discussed three types of understandings. One is a legal, scientific, and the economic understanding. Scientific understanding is not so important, but the second one is a tangible property and intangible property. These discussions is very important in understanding the concept of intellectual property. So let us focus, let us zero in on what is intellectual property. Intellectual property, the name clearly suggests it emanates from human brain, human mind, and this is called intellectual property. It emanates from human intellect. So this is why it's called intellectual property. And what is intellectual property rights then? The legal rights conferred over it by the society or the government, that is called intellectual property rights, IPR. So there are different types of IPRs. We'll gradually come to know in the different other sessions also. In today's discussions, we'll simply focusing on the types of intellectual property holistically. Earlier, earlier means before January 1, 1995, because after that TRIPS has come up. Before that, there are two types of intellectual property primarily. One is industrial property, second one artistic and literary property. Industrial property includes patent, industrial design, trademark, geographical indications, utility models, and trade secret or undisclosed information. And artistic and the literary property, there is only one category, copyright and the neighboring rights. And third one, there was no such category before 1st January 1995. India got 10 years grace period because India is a developing nation. So in India, it was implemented from 1st January 2005. Okay. Sui generis is a Latin word. It means a system of its own. And there is a story behind it. A story means is a technical story, obviously, especially the developing nations, South Africa, Brazil, and India. These three countries are the highly populated nations. But what happens to the country who are actually inventing the different products that are related with the computations, integrated circuits, databases, and the plant breeders? So there are many stressors group in the world. They stress and they actually stressed TRIPS, trade related aspects of intellectual property rights, is a is an agreement under the aegis of the WTO, World Trade Organization. India is a founding member. That India needs to, as India, there are many already different types of intellectual property rights, but they have observed as per their claim, they have observed over the years in India, South Africa and the Brazil, the intellectual property rights have been extremely violated as per their claim. So they want extensions or new objects needs to be come under the aegis of this intellectual property rights. So this is why they try to enter three new things over the already existing. Earlier it was not considered as a part of this intellectual property. So new things have been included. First one is a database, integrated circuits, and the plant beaters rights. So what happens? Let me discuss a little bit about this. What are the things? Industrial property, industrial designs, and then trademark, geographical indications. Let me discuss what are the things they are actually protecting. Patent protects inventions. Trademark protect identifying signs on the symbols. Possibly you know in the Coca-Cola case. I will show you this Coca-Cola case. Coca-Cola is a very unique case. Uh, Different types of trademarks are there. The designs is a ornamental design, is a card design, aeroplane designs, is a look and feel appeal. GI is a Bangla's Rasgulla, and then Kolhapuri chapels, and then Krishnanagar's clay modelings. All these are part of the GI because I told about the creativity, but the creativity can also be collective creativity. Creativity can be individual creativity, creativity can also be collective creativity. And the GI is not, say for a Darjeeling tea. Darjeeling tea, when we go to purchase tea in the market, normally we favor Darjeeling tea or Assam tea as per our choice and preferences. So what happens? We go for a particular Darjeeling tea or a Kangra Valley tea. Why are we calling this a Kangra Valley tea? That means we prefer that particular aroma that actually influences our decision. That's the geographical indications. This is called the collective creativity because over the years, centuries after centuries, people from Kangra Valley, people from Darjeeling, people from Assam, they nurtured, fostered, and protected this creativity for the generations to come. And this is why it is not an individual creativity. This is not an individual invention. This is a collective invention. Last one is a trade secret. Trade secret, say for a Nokuresh on this. Say for a trade secret as a Coca-Cola is a trade secret. So this way, a trade secret means the particular formula by which the particular liquid was made that is not known to anybody. Okay. And the copyright we'll be discussing on the copyright also. The what is a copyright? Copyright is given to a creator for the artistic and the literary things. PBR is a plant breeders rights. Valentine's Day is very near to us, 14th February, and possibly you notice that in the 14th February, even yes, we are having a different kind of roses we produce in India, but in the recent days we find a different kinds of roses we find which were earlier not available in India. So how did it happen? It's just because of the protection of the plant breeders' rights. When farmers are getting protections for their breeders' rights, they are producing, and it is based on the DUS plant variety. DUS means is a distinct, uniform, and the stable variety. And IC layout design, it's a colloquial name. Colloquial name is chip that we normally use for a mobile camera purpose, storage purpose. That's a IC design, integrated circuit design that IP protects. And the databases, any kind of databases, it might be scientific, biological databases, chemistry databases. So these databases are protected, but still now India is not protecting databases based on a new act as WTO was wanting. Still databases are protected in India through Copyright Act. Let me give you one example. This example says almost all four important components together. Coca-Cola, very interesting story connected with this Coca-Cola. John Pemberton, possibly in the 18th century or maybe the late 18th century, he invented that magical liquid. That magical liquid, that means a Coca-Cola. He submitted for a patenting purpose to the USPTO, United States Patent and Trademark Office. But after 14 days, he realized that after some day, when I will expire, what would happen to the inventions? What would happen to the economic benefit that might be given to our legal heirs? So immediately after 2 weeks, he went to USPTO Patent Office, United States Patent and Trademark Office, and withdrew his applications because he always wanted to make a secret forever. So he made it and trade secret. What is the basic difference between the trade secret and the patent? Patent is given for 20 years. We'll be discussing in the patent chapters. But still, I'm letting you know the patent is given all over the world after these harmonizations of the patent. 20 years all over the world in any country you go. But trade secret, the no time frame is given. Once the secret is compromised, everything is compromised. So see the example. This bottle design, it is covered by intellectual property, industrial design. And then the liquid, earlier he applied for the patent, right now it's a trade secret. And then trademark, the way it is written, the style, the font style. And the copyright, the expression, the way he expressed the term Coca-Cola style, that style is actually is a part of this copyright. So both patent or instead it's right now it's a trade secret, design, trademark and copyright all are embedded in a same bottle of Coca-Cola. So today's discussions, moot points, primarily we talked about the different types of intellectual property rights and what are the forms by which what kind of expressions can be protected and basics and the fundamentals of properties, basics and fundamentals of creativity aspects, its motivations, and then scientific background of these motivations, that means as internal motivation and external motivations, and how this intellectual property can be helpful to our society individually and collectively.